Welcome once again, students. So today we are going to discuss theories of divorce under HMA 1955. Before I'm going to discuss the substantive law regarding divorce as provided under Hindu Marriage Act 1955, let's have a very short story or summary of a theory of divorce. Different theories we have for divorce. Three different basic theories we have divorce, that is fault theory, or it is also termed as guilt theory, mutual consent theory, and the third one is breakdown theory. So these are very important theories. Breakdown theory is a very recent theory. Still, we do not have any legislative provision, very expressive provision regarding breakdown theory under HMA 1955. And mutual consent theory, this was the ground of divorce regarding mutual consent was only inserted after 1976 amendment and not in the Parent Act, that is in 1955, right? But the entire the structure of section 13 of divorce under Hindu Marriage Act 1955 is basically it consisted of fault theory or the guilt theory. But later on, after so many amendments, बहुत सारे changes were, like 1976. After 1976, mutual consent was inserted there in the form of 13B, and later on, this is a very new concept, breakdown theory. But this breakdown theory, at present, also it is still we does not have any expressive provision under Hindu Marriage Act 1955. So basically, the Supreme Court is only entitled to give a divorce on the ground of divorce, the decree of divorce on the basis of breakdown as per Article 142 of Indian Constitution. So let's start with it. So, students, basically divorce is basically was not an old concept. Old concept, I mean to say that it was not basically identified or recognized by the primary source of Hindu law, that is by Shrutis and Smritis. But later on, with the development of time, when we are saying that the nature of Hindu marriage is sacrament as well as contract. So at that, because of that only, several elements when inserted to have a valid marriage, then this concept was also inserted and adopted in Hindu Marriage Act 1955. And right now we have this concept, divorce, a very simple logic behind this. If you have a right to marry, you have a right to dissolve your relationship also. Okay, this is all in the light of article or part 3 of the Indian Constitution. So here we are talking about the different theories of divorce. So for very first of all, it was only the first source, Arthashastra, written by Kautilya, where marriage might be dissolved by mutual consent in the case of the unapproved form of marriages. Unapproved form of marriages means like that is Asur, Peshach, wo jo Rakshas marriage, they were the unapproved form of marriages. So for that only, basically it was said, or it was decided, recognized that yes, by the mutual consent, such type of marriages may be dissolved, or the spouse they are entitled to live separately. So it means they can terminate their relationship. But otherwise, for the approved form of marriages, such concept of divorce, that is Vivaha Vichhed, was not allowed and recognized. So these are, here we have some theories. The very first theory is fault theory, or the offense theory, or the guilt theory. These are different names. Marriage can be dissolved only when either party of the marriage has committed a matrimonial offense. Generally, the entire structure of divorce has been built on fault theory. Now, one more thing, Dissolution of Muslim Marriage Act 1939. The entire structure of Dissolution of Muslim Marriage Act 1939, where we are saying that women has a right to dissolve the marriage, that also basically the entire structure of that also, that is section 2. Section 2 of Dissolution of Muslim Marriage Act 1939 is also basically consists of this fault or guilt theory. There are 9 specific grounds of divorce in it, जैसे cruelty है, adultery का है, maintenance का provision है, तो कुछ बहुत सारी उसमें ऐसी चीजें हैं जो कि उसमें डाली गई हैं. It means for the Muslim law also, अगर हम Muslim law की बात करें तो वहां पे भी इस guilt theory, fault theory का provision है. Now the second one is mutual consent theory. The underlying rationale is that since two persons can marry by their free will, they should also be allowed to move off the relationship of their own free will. This is a very important case, Jagraj Singh versus Birpal Kaul, 2007, and the provision is inserted in the form of 13B as per the amendment of 1976. The next very important is or you can say this is a recent ground of divorce, that is the breakdown theory. And this breakdown theory is defined as such a failure in the matrimonial relationship or such circumstances adverse to that relationship that no reasonable probability remains for the spouse after living together as husband and wife. That is Kohli versus Kohli case, a very leading case, 2006. What does it mean? Actually, breakdown, what does it mean? Breakdown means when there is not a single chance, student, to repair or to restore or to reunite the relationship, when there is nothing can be happened, there is no other solution, no other alternative, कुछ नहीं बचा शादी में साथ रहने के लिए, इतना रिलेशनशिप टूट चुका है या बिखर चुका है, दोनों जो हस्बैंड वाइफ है वो किसी भी कंडीशन में साथ नहीं रह सकते. So for the purpose of this breakdown theory, court base, what is the object of the court? Not to look into the guilt or fault of the spouse, but let's see कि क्या, is there any condition, is there any circumstances in which these people are able to live with each other? If it is not possible, to simply go with this, you just simply terminate your relationship. The court generally terminate the relationship under the special power of 142 article of the Constitution. So this is a very general sense. And the next important is that this is all about breakdown theory. I have elaborated here. So breakdown theory is, this is not a special ground for divorce under HMA, that I have already told you. An attempt has been made to introduce the concept in section 13(1)(a) as per the Marriage Amendment Bill 2013. But still it is not final, students. It is just only a bill. तो लेट्स सी कि क्या ये बिल का कॉन्सेप्ट क्लियर होता है कि नहीं होता है, ये एक्ट बन पाता है कि नहीं बन पाता है. दिस इज ऑल अ मैटर ऑफ अनसर्टेनिटी. सो हियर it is pending. And regarding this breakdown theory, of course, a detailed analysis you will find out in 71st Law Commission report. There are certain leading cases, Kohli versus Kohli, so Shyam Sundar Kohli. Supreme Court, what held this is, Supreme Court used this ground of divorce in the rarest of the rare case, because already we have two different grounds. अगर किसी का गलती है, पति या पत्नी का कोई गलती है, फॉल्ट है, गिल्ट है, ऑफेंस अगर कुछ किए हो, तो आप जो है सीधे सीधे फर्स्ट थ्योरी को यूज कर सकते हो और उसमें डिवोर्स का डिक्री बाय कॉम्पिटेंट कोर्ट मिलता है. सेकंड में अगर आप करते हो बाय म्यूचुअल कंसेंट, इफ यू आर नॉट अग्री टू लिव विद ईच अदर, not comfortable in the relationship, not able to perform the matrimonial obligation with each other, तो ठीक है, you can go for that, you can go for mutual consent. तो 13B आपके पास एक सीधा सीधा का रास्ता है. तो there is a question mark, because in India number of NGOs and women association basically is not, they are not ready to accept the breakdown the theory of divorce, because उनका ये कहना है कि now it's very easy to take divorce and the people are now free, they are free to terminate their relationship. So what is the motto of marriage? The object of marriage is to maintain peace and harmony in the society. Somehow कहीं ना कहीं वो खराब हो जाएगा, and we are fail basically to save the marriage, the institution of marriage in the society, in the Indian society. So somehow for so many reasons, for different reasons, some organization and women association are still not recognizing or considering this ground as a legislative or expressive provision under HMA. So this ground is provided by the use of extraordinary power provided under 142 of the Constitution. And this is Swaraj, Garg and Ye, where there's a breakdown of marriage. This in itself should be a cause for which divorce should be available under the law. So this is the basic call. This is the important rationale behind it. You can say this is the rationale behind breakdown theory कि क्या कोर्ट सोचता है, डिवोर्स अगर ब्रेकडाउन का देना है, ब्रेकडाउन ग्राउंड पे देना है, तो क्या कोर्ट की सोच है. दिस इज देयर कि जब शादी ही पूरी तरीके रिश्ता ही खत्म हो गया है, दोनों के बीच में कोई एफिनिटी नहीं बची, किसी तरह का रिश्ता नहीं बचा, कोई अफेक्शन लव जैसी कोई चीज नहीं बची, तो व्हाई इट इज रिक्वायर्ड कि हम उस रिश्ते में चलें, क्यों ना उसको खत्म कर दिया जाए. So this is the basic idea of breakdown theory. So court basically is this, it is only the court it is only the instance of the court on which the judgment may be delivered by competent court on the basis of this breakdown theory. So this is number 2. This is mutual consent theory as provided by the amendment 1976, that is in the form of 13B. राइट सो ऑफ कोर्स हस्बैंड और वाइफ दोनों ही कर सकते हैं, हस्बैंड और वाइफ दोनों ही म्यूचुअल एक एप्लीकेशन सबमिट करेंगे, दोनों का एप्लीकेशन होना चाहिए एंड द बेसिक रीजन एंड द ग्राउंड for the submission of 13B is that the parties have to prove it that they are living separately from last 1 year from each other. Separately means they are not in a position, they are able to prove it that there is no matrimonial relationship like a husband and wife between them. तो वो ये बात अगर प्रूफ कर पाते हैं कि एक दूसरे से बिल्कुल अलग है, कोई शादी से संबंधित कोई संबंध नहीं है उनमें, अगर वो ये प्रूफ कर सकते हैं, मिनिमम पीरियड इज 1 year एटलीस्ट, कम से कम 1 साल, मैक्सिमम बात नहीं कर रहे हैं हम, बात कर रहे हैं मिनिमम की, तो मिनिमम एटलीस्ट 1 year इज रिक्वायर्ड for the submission of for the submission of application under 13B of HMA 1955. Now and the parties have to prove that they are not able to live with each other anymore, or the cooling period is of 6 months, that is 6 to 18 months. And here it is that once the at the time when the parties submit the application in the court, in the district court regarding mutual consent 13B, the court initially will not take any step for the first 6 months. 6 महीने तक कोर्ट कोई स्टेप लेता नहीं है. कोर्ट का ये सीधा सा लॉजिक ये है कि हो सकता है किसी प्रोवोकेशन की वजह से, कोई मिसअंडरस्टैंडिंग की वजह से the parties are not comfortable with each other, that is their idea कि they don't want to live with each other, तो कोर्ट कोई एक्शन लेता नहीं. For इस रीजन के लिए हो सकता है within this 6 month period the parties are able to withdraw their application. तो कोर्ट का जो बेसिक मोटिव है to save the institution of marriage, तो वो सॉल्व हो जाएगा बहुत अच्छे से. So here the court will not take action for next for 6 months, and then 6 to 18 months. Basically, it is the period. Then a proper inquiry will be by the court, and then if it is found that yes, the parties are now not able to live with each other, the competent court will pass a decree for 13B, and the relationship, and now the relationship between the spouse will be terminated, and now they are able to solemnize their second marriage. So this is basically the important idea of mutual consent. Now this is 13, actually section 13. Section 13, as I have already told you, basically this section 13 is the very important section which was actually inserted in the Parent Act, that is 1955. So here we are talking about this section 13 actually categorized into two. 13 जो हमारे पास है 13(1) और 13(1)A अलग से किया हुआ है. वो सिंपल सीधा सा कारण है कि 13(1) basically is all about some specific grounds of the divorce which exclusively recognize for both husband and wife. कि पति या पत्नी में से कोई भी अगर कोई भी फॉल्ट करता है, कोई गिल्ट करता है, कोई ऑफेंस करता है, कैसा भी हो, तो सबके लिए उसको ग्राउंड मिलेगा. पर जब हम 13(1)A की बात करते हैं तो उसमें हमें देखने को मिलता है 13(1)(2) में जब हम बात कर रहे हैं अलग अलग ग्राउंड्स की, तो हम ये देखते हैं कि these specific grounds are exclusively available to the Hindu wife only. सिर्फ पत्नी को कुछ अधिकार एक्स्ट्रा मिले हुए हैं सेक्शन 13 में. तो इट मींस द एंटायर स्ट्रक्चर ऑफ सेक्शन 13 इज बेसिकली फॉर्म्ड ऑन द बेसिस ऑफ गिल्ट और फॉल्ट थ्योरी. तो these are the general grounds. The very first of all, adultery. Adultery, after the amendment of 1976, a petition for divorce can lie the instance of the husband and wife. What is required for the adultery? Intercourse after solemnization of marriage. कि शादी के बाद इस तरह का intercourse किया गया हो, out of the spouse means out of the relationship, marriage relationship के बाहर किया गया हो. Before amendment, spouse is having in adultery was required, but now a single act of adultery is sufficient. It means कि अभी अगर हम बात करें अमेंडमेंट से पहले यानी 1976 से पहले कंटिन्यूटी होना चाहिए था एक्ट में. A continuity is required in adultery, but after 76 only one act of adultery is sufficient for 13. For section 13, intercourse will be voluntary with a person other than his or her spouse. This is also required. And the very last one, condonation of adultery is an absolute bar to granting any relief by way of section 10 or by section 13(1). Condonation of delay, that is provided under section 23 of HMA 1955. If there is a condonation of relationship, you know that कि सर मेरी जो पति है वो इस तरह का काम कर रहा है, या पत्नी वॉलंटरी इंटरकोर्स कहीं पे कुछ कर रही है, या पति कुछ कर रहा है, पर आप ये जानते हुए भी अगर आप कॉन्डोनेशन कर रहे हैं, इसका मतलब स्टिल यू कहते हैं कि ठीक है, या तो गलती से हो गया होगा, या कुछ हो रहा होगा, मिसअंडरस्टैंड कुछ आपका, दिस इज योर आइडिया, दिस इज योर परसेप्शन ओनली, राइट। अगर आप फिर भी कर रहे हो और आप माफ किए जा, फॉरगिवनेस अगर चल रही है, एंड स्टिल यू आर मेंटेनिंग द पोजीशन ऑफ अदर स्पाउस एज इट वाज अर्लियर बिफोर द कमीशन ऑफ द एक्ट, गेटिंग माई पॉइंट। तो अगर वैसा है तो कोर्ट अगर सेक्शन 23 में इसको देखता है कि कॉन्डोनेशन किया है दूसरे स्पाउस ने इस एक्ट के कमीशन के बाद ने भी, सो व्हाट, द कोर्ट विल नॉट अलाउ द पार्टी टू टेक रिलीफ ऑन द बेसिस ऑफ दिस ग्राउंड। So what is required? इसका मतलब one party must be completely innocent and the other party जो है वो commission of the crime करेगा ही करेगा, but the thing is that there must be no condonation. तो अगर first instance में अगर केस हुआ है, आप रिपोर्ट करते हैं तो condonation नहीं, पर आप condonation करे जा रहे हैं, गलतियों को forgive किए जा रहे हैं, तो court will generally not consider the relief which was like prayed by you. The second is cruelty. This is very, very important, students. Cruelty, very first of all, before amendment 1976, this cruelty basically was not a ground of divorce. Actually, it was ground only section 10 of judicial separation, right? But later on, after 1978, it becomes a ground of section 13 also, that is divorce. So here I am talking about, here I would like to tell you that now the concept of cruelty, we cannot, there is we cannot limit, okay, the act, we cannot limit the acts of cruelty. Actually there is no fixed parameter, or there is no schedule, or there is no act, there is no list of acts where we can say that these XYZ acts are considered as cruelty only, because cruelty now, this concept is so broad that it itself include mental as well as physical. जो assault या libel की हम बात करते हैं, तो physical injury होए, आपका mental injury होए, आपका economical injury होए, आपका इस तरह का कोई भी injury अगर आपका है, तो वो cruelty के basis पे count होने लगा है. The concept is so broad, बहुत सारी चीजें इसमें शामिल हो गई हैं, ठीक है? तो it includes physical as well as cruelty. What does actually what is the concept of cruelty? होता क्या है cruelty? It means conduct of such character as to have caused danger to life, limb or health, body or mind, or as to give rise to a reasonable apprehension of danger. Now the last two, three words are very important, students. Reasonable apprehension. It means always the one of the party basically ये हमेशा उसको एक जो है उसको हमेशा ये एक डर लगा रहता है कि कुछ मेरे साथ गलत हो जाएगा, हमेशा मेरे साथ मेरा जो हस्बैंड है या मेरी वाइफ है वो मेरे साथ ऐसा कुछ कर देगी, मुझे हाथ पे कुछ प्रॉब्लम हो जाएगा, हाथ टूट जाएगा, पैर टूट जाएगा, या कुछ और आपको ऑलवेज देयर इज अ रीजनेबल एप्रीहेंशन इन योर माइंड रिगार्डिंग योर बॉडी इंजरी, रिगार्डिंग योर मेंटल माइंड, जो भी कुछ, तो ये सारी ऑल दीज थिंग्स टुगेदर विल बी टर्म्ड एज अ क्रूएलिटी. This conduct basically being termed as a cruelty. So a very leading case we have, that is Samar Ghosh versus Jaya Ghosh. Mental cruelty has to be established from the facts and no direct. There is no direct evidence for mental cruelty. आप decide नहीं कर सकते, कोई सीधा जवाब नहीं होता कि ये mental, हमारे पास एक reasonable apprehension in the mind के सब मेरा पति या मेरी पत्नी मेरे को ये नुकसान पहुंचाएंगे. So mental cruelty is to be decided not exclusively by the facts. There is no direct evidence, but it is to be decided by the circumstantial evidences also. So by the other ways we can decide it. So now, but what is required? That is exclusively this cruelty includes mental as well as physical. So very important case, all you know that is Dastani versus Dastani case, like 1975. Condonation of cruelty is an absolute bar. Condonation of cruelty is an absolute bar for granting any relief by way of section 10 or by section 13. तो condonation जो है, अगर आप इसमें भी section 23 का application, the court will consider the strict application of section 23 before granting a relief अंडर सेक्शन 13 रिलेटेड विद क्रुएलिटी, कि अगर जैसे दास्ताने वर्सेस दास्तान में कॉन्डोनेशन ऑफ रिलेशन हो गया था दोनों हस्बैंड वाइफ के बीच में, पत्नी थी थोड़ी वो शॉर्ट टेम्पर हुआ करती थी, और पति थोड़ा सा लिबरल एटीट्यूड का था, बच्चों से प्यार करता था, और पत्नी थोड़ा बहुत गुस्सा होती थी, एरोगेंट नेचर की थी, गुस्सा करती थी, बट बिकॉज ऑफ दैट व्हाट हैपेंड, नाउ देयर इज अ कॉन्डोनेशन बिटवीन दास्ताने, मिस्टर दास्ताने एंड मिसेस दास्ताने. सो व्हाट द कोर्ट सेज कि नहीं, मिस्टर दास्ताने, यू आर नॉट सपोज्ड टू गेट दिस रिलीफ बिकॉज यू हैव ऑलरेडी कंडोन द रिलेशनशिप. आपने पूरा के पूरे किया, तो आपको क्रुएलिटी के कोर्ट ने डिसाइड माना कि क्रुएलिटी थी, पर कोर्ट ने मना किया कि आप क्रुएलिटी के बेसिस पे डिग्री नहीं ले सकते डिवोर्स का सेक्शन 13 का, बिकॉज देयर इज एन एब्सोल्यूट बार ऑफ सेक्शन 23 ऑफ HMA 1955. So what it means, it must the bar of section 23 absolutely be considered by the court. So this is the very important third point, desertion. Desertion again after 76 amendment only it becomes a ground of section 13. Earlier it was not there. Somehow section 9 of HMA 1955, that is restitution of conjugal right as well as desertion, somehow related. In section 9 we were discussing, we had discussed that section 9 restitution, why the relationship, why it is required that the conjugal right must be restored or reunited, because the other party, because the spouse basically they are withdrawing themselves from the society of others without any reasonable cause. तो कोर्ट क्या करेगा, नहीं रेस्टिट्यूशन करेगा आपके रिलेशनशिप को, बोलेगा कि आप साथ रहिए, आप एक शादीशुदा जिंदगी को जिए, और आप इस तरह से एक वैवाहिक जीवन जो है आप बनाए रखिए, और बिना रीजनेबल कॉज के आप अलग नहीं रह सकते, जेन्युइन एक रीजनेबल कॉज होना चाहिए अलग रहने के लिए. तो डिजर्शन इज somehow or it is just like that. कि desertion we are talking about कि if there is the essence of desertion is the forsaking abandonment of one spouse by the other without reasonable cause and without the consent or against the wish of the other. तो आपने बिना पूछे, बिना consent लिए, या without any reasonable cause, if you are living separately and there is no matrimonial relationship in between you and your spouse, so what? It will be considered as a desertion. So what is required? Two essential elements we have for to prove desertion: animus descendi, that's the intention of permanent end of cohabitation, and the second is that is the factum of desertion, and the third is desertion amount to matrimonial offense must be for a continuous period of not less than 2 years. तो म्यूचुअल कंसेंट के लिए हमने आपको क्या बताया, 13B के लिए कम से कम 1 साल होना चाहिए कि आप साथ नहीं रहते हैं. डेजर्शन के लिए आपको 2 साल चाहिए प्रूफ करने के लिए कि पिछले 2 साल में हमें मेरे और मेरी पत्नी के बीच, पति कह सकता है या पत्नी कह सकती है, मेरे और मेरी पत्नी के बीच या मेरे और मेरे पति के बीच में पिछले 2 साल से किसी भी प्रकार का वैवाहिक संबंध नहीं है. तो ये अगर प्रूफ किया जाएगा, then it become a ground of desertion. So this is a very important case. Bipin Chandra Jai Singh Bhai Shah versus Prabhavati 1950 said this is a very leading case. So students, desertion here means that is there must be the very important element for to prove desertion is animus descendi, that is 2 number, that is there is a complete intention to permanent end of cohabitation, के वैवाहिक संबंध पूरी तरीके से खत्म करने का एक आपका पूर्ण तरीके से मंतव्य है कि आप इस शादी को कंटिन्यू नहीं करना चाहते और इस वैवाहिक संबंध में आगे नहीं बने रहना चाहते. तो ये आपको प्रूफ करना पड़ेगा. नाउ दीज आर नेक्स्ट वेरी इंपॉर्टेंट grounds of divorce under 13. So that is cease to be a Hindu by conversion. आप अगर हिंदू नहीं रहते हैं और धर्म परिवर्तन कर लेते हैं तो भी आप डिवोर्स का कारण एक बन सकता है. तो हस्बैंड और वाइफ दोनों के लिए ये एप्लीकेबल है, दोनों ही ये कर सकते हैं. आपने लिली थॉमस सरला मुद्गल केस आपने इसके बारे में पढ़ा होगा. अगर आप शादी को खत्म नहीं करते हैं और धर्म परिवर्तन कर लेते हैं, then what happened? It become a case of bigamy then. So what is required? Before conversion, a marriage relation must be terminated. तो वो पूरी तरीके से खत्म होना चाहिए. अगर नहीं है तो it become a ground of divorce and bigamy also. So Sarla Mudgal and Lily Thomas case. So unsound mind or suffering from mental disorder, unsoundness of mind or mental disorder to such an extent that the petitioner cannot reasonably expected to live with the respondent. So again this is a problem कि अगर आप mentally abnormal हैं, है ना, मेंटली आप एबनॉर्मल हैं, मेंटल डिसऑर्डर हैं, तो उसकी वजह से भी द पार्टीज इफ आर नॉट एबल टू लिव विद ईच अदर, ऑलवेज हमें एक रीजनेबिलिटी, एक रीजनेबल एप्रीहेंशन, डर बना रहता है दिमाग में कि साहब मैं इसके साथ कैसे जीवन यापन, वो बहुत ही डिफिकल्ट है. तो भी ये एक ग्राउंड बन सकता है. Incurable or venereal leprosy, this was earlier before 2019 act, but now leprosy is no more a ground of section 13. It was like this leprosy ground is omitted by the Personal Laws Amendment Act 2019. Next is venereal disease. When other party has been suffering from the venereal disease in a communicable form, तो एक दूसरे से कम्युनिकेट होता है, जैसे एक एड्स एक बीमारी है, एंथ्रेक्स एक बीमारी है, तो ऐसा कुछ इस तरह की बीमारियां हो जिससे डर है कि साहब दूसरा पार्टी को ये कम्युनिकेट होगा इजीली, तो दूसरे के रिस्क ऑफ द लाइफ अगर होता है तो it may be considered as a ground of divorce under 13. Now, renunciation, the world party has renounced the world by entering any religious order. His or her action is tantamount to civil death, like sannyasi, sadhu ban jana, sadhvi ban jana. ठीक है, इस तरीके से जैसे दीक्षा ले लेते हैं जैन धर्म में, just an example. So basically then it also becomes a ground of divorce. Presumed death, at least 7 years are required for the presumption of death under the Evidence Act also. So what is required? Where other party has not been heard or has been living alive for a period of 7 years or more by those person who would naturally have heard of it had the party been alive. तो 7 साल कम से कम ना देखा जाए ना सुना जाए, seen and heard of any person, at least minimum of 7 years. So then such on the basis of this ground also, कारगिल में लड़ाई किया, suppose करो कारगिल में किया, ग्लेशियर्स में कहीं दब गए, सियाचिन में कहीं रह गए, या पाकिस्तान की जेल में चले गए, नॉट प्रॉपर्ली इन्फॉर्म्ड, 10 साल 7 साल 8 साल 10 साल बाद कोई इंफॉर्मेशन नहीं है, so the parties are able to take divorce on that ground also. So next is court pass a decree of divorce on showing that there has been no resumption of cohabitation for 1 year or more after the decree of judicial separation, that is section 10. 1 साल हो गया है, आपने जुडिशियल सेपरेशन की डिग्री को 1 साल हो गया है, और कोई भी इंस्टीट्यूशन ऑफ मैरिज को सेव करने का जो ऑब्जेक्ट है कोर्ट का, that was actually failed, right? That was actually failed. So what then? The section 10, the decree of section 10 become a ground of divorce under section 13 in the point number 10. And then point number 11, it's all about section 9. No restitution of conjugal rights and between the parties to the marriage for a period of 1 year or upwards after passing of the decree become the ground of divorce. So again, this is all about section 9. Okay, decree has been passed in section 9 by a competent court, but still the parties are not living with each other, and they are not observing matrimonial relationship in between each other. So what? It become a ground. For that, at least 1 year is required. So what? Then it becomes a ground of divorce under section 13 as provided under section 13. Now there are certain grounds. 13.2 basically. We have 4 grounds here in 13.2. So these 13.2 basically we have 4 grounds, and these 4 grounds exclusively available to Hindu wife only and not husband. तो 13.1 जो था वो पूरे के पूरे हस्बैंड के लिए, 13.2 जो है वो पूरे के पूरे वाइफ के लिए है, और 13B वो दोनों हस्बैंड वाइफ के लिए, क्योंकि वो म्यूचुअल कंसेंट है. यहाँ हम सिर्फ पत्नी की बात करते हैं. सो यहाँ 4 ग्राउंड हमारे पास हैं, and these are very simple ground. The very first is when we are talking about bigamous marriage, agar ho to marriage solemnized before commencement of the act and the husband having more than one wife alive at the time of presentation of the petition. तो या एक से ज्यादा अगर शादियां है, बाइगेमी अगर पॉलीगेमी किया है, पॉलीगेमी अगर किया है तो जो है पत्नी उसके लिए divorce का petition file कर सकती है. Husband has been guilty of rape, sodomy and bestiality. And the third one is if it is a case of 125 CRPC and section 18 of Hindu Adoption and Maintenance Act 1956, then also if a petition is pending here, then what happened? Then also the wife is entitled to get divorce under section 13. She is able to submit a file and petition in the court for 13. And then last is option of puberty, right to repudiate the marriage if a child marriage is solemnized, that is before 15, less than 15 years, then such women, such Hindu wife is able to repudiate the marriage, terminate the marriage. Repudiation, this is option of puberty she had, and this can be availed if marriage is solemnized before 15, but she is able to repudiate her marriage before getting 18 years. But this provision of option of puberty is to be read in the light of PCMA 2006 also. तो वहां पे आप सेक्शन 3 के प्रोविजन में PCM में इसको आप पढ़ेंगे उस लाइट में, और ये आप देखेंगे कि कितना ग्रेस पीरियड हमें 3 साल का जो ग्रेस पीरियड है वो मिला हुआ है, 2 साल 3 साल का जो ग्रेस पीरियड है हमें वो मिला हुआ है। और एक लड़का एक लड़की, and PCMA of course is a secular law, so it is equally applicable to male as well as female, but here we are talking about only female, that is Hindu wife only and not Hindu husband. So these are general grounds of divorce provided under Hindu Marriage Act 1955.